South China Sea, site of long-running territorial disputes. From China and Malaysia to Vietnam and the Philippines, several countries claim sovereignty over the sea's islands, reefs and waterways, leading to geopolitical tensions and security concerns. What is the significance of these waters, and how did the conflicting claims originate? Are China's actions and growing presence there inconsistent with international law, as many argue, or do different interpretations of maritime law cloud the issue? And how can the various nations' claims and counterclaims be reconciled, if at all? To explore the South China Sea disputes from a legal, geopolitical and security perspective, stay tuned to our debate with your questions and comments for the panel.
Hello and welcome. I am Humphrey Hawksley. This is the Democracy Forum debate where our expert panel drills down on difficult issues. And today we're looking at one that has simmered for decades, yet it could erupt at any moment. Territorial claims in the South China Sea, a question of legality. Given the new direction of the United States, our title itself might be out of date. If Washington can take Panama and Greenland, surely Beijing can build a handful of islands in international waters. In this new era, what exactly is legality? To debate this, we have a really superb team. Bill Hayton, Nong Hong, Pooja Bhatt, Collin Koh, and Gregory Poling. But before I go to them, I'm going to ask Lord Charles Bruce, President of the Democracy Forum, to lay out the background and the canvas of our debate. Lord Bruce, the floor is yours.
Good afternoon and welcome to our webinar, which will examine China's claims of sovereignty over most of the South China Sea. I'd like to thank the team at Democracy Forum for arranging this event and presenting such an important topic for debate and discussion. We're very fortunate to be able to call on such an impressive panel of experts to guide us through one of the most prominent and consequential disputes of maritime jurisdiction anywhere in the world. And I'm very grateful that Humphrey Hawksley is acting as our moderator today. China's claim to around 90% of the South China Sea, an area of over 3.5 million square kilometers, comprises a vital maritime trade and transportation route for many East Asian and Southeast Asian states and their trading partners in the Middle East, Asia, and Africa. It's estimated that around 24% of global maritime trade passes through the South China Sea and East China Sea, a trade worth $7.4 trillion annually. And with abundant fisheries and expanding prospects for oil and natural gas, the South China Sea may contain up to 9.2 billion barrels of untapped petroleum and up to 216 trillion cubic feet of natural gas. China's territorial claim is delineated by a 9-dash line, first recorded over 70 years ago, enclosing 4 uninhabited island groups together stretching for 1,800 kilometers from north to south and 900 kilometers in width. Despite ratifying the United Nations Convention of the Law of the Sea, UNCLOS, in 1996, the legal criteria China employs to justify its territorial rights in the South China Sea is based on domestic, not international law. And furthermore, its claim appears to be deliberately vague and ambiguous. It's not supported by coordinates, and it doesn't distinguish between terrestrial or maritime space. Yet, it arbitrarily cuts across the continental shelf of 6 neighboring coastal states: Vietnam, Philippines, Malaysia, Brunei, Indonesia, and Taiwan. In 2012, following several provocative incidents and naval incursions, China tested the writ of UNCLOS by seizing the Scarborough Shoal, which lies within the Philippines' 200-mile EEZ. And although China refused to participate in the subsequent proceedings at The Hague, the Permanent Court of Arbitration in 2016 found in favor of the Philippines, ruling that China does not exercise exclusive control over the waters contained within the 9-dash line and has no legal basis to claim historic rights to the resources. Importantly, it ruled that the exclusive economic zones in the South China Sea can only be calculated from the baseline of littoral states' coastlines, not from isolated rocks and reefs, thus shrinking the area claimed by China from 90% to around 2.5%. Reflecting on the ruling and the consequences for the exercise of China's regional hegemony, some analysts conclude, I quote, "China knows that claiming everything within the U-shaped line is fanciful." Indeed, The Economist goes as far to describe such an attempt at territorial appropriation as, I quote, "a U-shaped tongue of passive cartographic aggression." In other words, the issue of legality has really never been paramount. Instead, it should be seen for what it is, an exercise, I quote, "of promoting and overselling domestically an unrealistic and indefensible understanding of China's rights in the South China Sea." Well, thank you very much for deciding to watch our webinar today. And if you have any questions or queries, please pass them to the panel through the chair.
Thank you, Lord Charles Bruce. 24% of global maritime trade through a stretch of water, but who controls it? Who owns it? What are the laws surrounding it? And what is this 9-dash line? We are going to find out or debate it. Our first panelist is Dr. Bill Hayton, Associate Fellow at the Asia Pacific Programme at Chatham House. That's the Royal Institute of International Affairs. A historian and analyst with a deep knowledge of Asia and the South China Sea, author of The South China Sea, Dangerous Crown, and another book called The Invention of China, Is the Dragon Not What It Seems? Bill Hayton, give us your historical perspective on this issue and why it matters.
Great. Thank you very much indeed, Humphrey. Thank you again. I'll talk a little bit about the history, and I'll just draw a distinction between territorial claims, i.e. claims to the rocks and the reefs, and maritime claims, what you do in the spaces in between the rocks and the reefs. But I just want to talk about how China's claims in the South China Sea emerged. I'll try and persuade you that in fact they are a mistake. The mistakes were made in the early 20th century and that they are still affecting international politics to this day. So if we have the first slide, we can show that we can demonstrate this from a Chinese publication. The Republic of China, a nationalist government of Chiang Kai-shek, produced a book towards the end of the Second World War, the China Handbook. One edition was published in 1943, and then a second edition was published 4 years later in 1947. And in page 1 of the first edition in 1943, it says China's territory extends as south as the Paracel Islands. But in the second edition, which was published 4 years later, you can see the same page says China's sovereignty extends as far as what it then called the Tuansha Islands, which China now calls the Nansha Islands, in English, the Spratly Islands. So you can see that in 4 years, China's claims to the South China Sea actually dropped, went further south by 1,000 kilometers. China claimed an extra 1,000 kilometers in those 4 years. So why was this? Well, it's all to do with this thing called the U-shaped line. As you can see, where the clashes have been taking place in the South China Sea recently are all pretty much at the edge of this U-shaped line, close to Vietnam, close to the Philippines, to Indonesia, and to Malaysia. So there's something special about this U-shaped line. So how did China come to draw it? Well, it was first published in a Chinese government document on this map here, in 1947, late 1947, and you'll see that you have these dotted lines. In 1947 there were 11 of them, but a couple were taken out in the 1950s, meaning it's now the 9-dash line. And you'll see it goes very close to the coasts of Borneo, Malaysia and Brunei, and quite close towards the Tuna Islands of Indonesia as well. So how did this come to be drawn? Well, it was drawn by two people who were seconded to the Chinese government at the end of the Second World War. And they were summoned to a meeting in September 1946. and a guy called Chris Chung, who teaches at the University of Toronto, has looked at the documents and seen the minutes, and they were there to just, with this instructions, to decide what China should claim at the end of the Second World War. But the arguments about exactly what China should claim continued all the way through 1946 and 1947, and there were different positions. And in December 1946, China sent an expedition to the Spratlys, and for the very first time in history, a Chinese official actually landed on the Spratly Islands in December 1946. Even the commander of that expedition didn't think that China should claim Spratly Islands. But he was overruled by the officials, and they chose a piece of the South China Sea known as the James Shoal in English. So why did they do that? It's very strange, because the James Shoal isn't an island, it's actually underwater. So why did China claim an underwater feature to be its southernmost point of Chinese territory? And it's partly because of these two people, the geography professors. They were on the committee, and you'll see in the middle there a picture of one of them on the expedition to the Spratly Islands in December 1946. What these two geography professors had in common was that they were students of a man called Bai Mei-chu, who had been a geography professor in his turn in the 1920s and 30s in Beijing. This man here, Bai Mei-chu, and he, in 1936, published his own atlas of China's territory. You see a copy of the cover on the right there. And in that atlas, he drew a map of what he thought China's boundaries should be. And as part of that map, he drew a red line around the South China Sea. And you'll see it's very similar in shape to the shape line, the 9-dash line of today. He was the first man ever to draw this line in this shape. But he wasn't a government official, he was just a geography professor who had his own ideas. But what's remarkable about this map, as you see on the right, is that a whole load of these islands that he draws don't actually exist. There are no island in the middle of the South China Sea there. And towards the end, the extremities of this line down in the south, you'll see some little pink things coloured in. Those islands don't exist either. They are underwater features, the James Shoal and the Vanguard Bank there. So why did he draw his line around these non-existent features? Well, it goes back to a Chinese government committee in 1935, which attempted to regularize the maps of China. And it did so by copying all the names from mainly English British maps of the period. And they simply translated the names into Chinese. But when they did so, this government committee, there were mistakes. So there's this feature, this shallow area of sea called the James Shoal, which the Chinese officials translated its name as the Zhengmu Tan. Zhengmu is simply the transliteration in Chinese of the English word James. And Tan is an ambiguous word that means sandbank. And so when Bai Mei-chu saw the name Zhengmu Tan, the James sandbank, he thought it was an island. And so he colored it in his map in pink, and then he drew his line around it. And the same thing applied to the Vanguard Bank, which was known in Chinese by this committee as the Chanwei Tan, and to the Haima Tan, the Seahorse Shoal. These were three features which he interpreted as above water features. But why did he choose those three? Well, I think he simply copied this British map, which shows Seahorse Bank in the top right near the Philippines, James Shoal down south near Malaysia, and the Vanguard Bank closer to Vietnam. And he misunderstood this map. He thought that these were islands. In fact, they were underwater features, and he drew a line around it. So that, unfortunately, is the origins of China's U-shaped line. It's a complete mistake created by some bad map making based on some bad translations of British maps. And you can see that throughout his map, as I show on the right there. But what's a tragedy today is that this line is the cause of so much friction in Southeast Asia, where the clashes are taking place with the Philippines, with Vietnam, and with Malaysia and Indonesia to a lesser extent, are all over these areas of these non-existent islands. It doesn't have to claim them, it does, and that's why the conflicts continue, the disputes continue. But it would be possible to undo all this mistake. Singapore and Malaysia have shown how you can go to an international court and you can ask the court to rule on who has the better claim to things. And you can see in this picture how close the different disputed islands between Malaysia and Singapore are, and yet a court was able to work out a legitimate claim for each of these countries. The same thing could be done in the South China Sea. If you just allowed each country to claim what it currently occupies, it would be a way of some kind of de facto recognition and to take down the heat of the conflict. So it is possible, theoretically, to resolve these competing claims to the different rocks and reefs. Only a few of the features of the South China Sea have actually changed hands since they were first occupied during the 20th century, and I'm sure some way could be done to accommodate those differences. And once you do that, you then shrink the area that's under dispute just to the actual real islands of the Spratlys. You leave the areas which have been under the most intense dispute aside. They are given the coastal states, the Philippines, Vietnam, Malaysia, etc., and you just focus your dispute on the actual solid islands in the Spratlys. So in theory, it should be fairly simple to resolve China's claims and the disputing claims in the South China Sea. And it's a mystery to me why China doesn't realize that it would be much better for its relations with its neighbors if it did so, and why it continues to insist on this U-shaped line, which causes so much trouble between China and its neighbors in South China Sea. I'll leave it there.
Thank you very much. That was fascinating. So we have an international issue, which is the result of mistaken and bad translations of British maps. Can I take you to our most recent history, whereby international law seems to be thrown out of the window a bit, or highly questioned? So when you said the Chinese don't realize, they must realize it, but they just don't want to do it. Is that right?
Well, I suppose, we might get some different answers in this webinar, but there are different lobbies in China, I think, that want to push for a maximalist claim in the South China Sea. You have the Navy and the Coast Guard that get big budgets for pushing their claims to the maximum extent. You've got the oil and gas industry that wants to exploit the resources. You've got the fisheries industry. But I think overall is maybe just this sense of nationalism, that you don't want to challenge claims of previous generations, even if they don't make much sense.
And if they did accept your thesis just now, what would they have to forfeit in regards to the islands that they've built up in the past 10 or 15 years?
Well, I suppose my hypothetical suggestion is that everybody keeps what they currently occupy. Nobody physically gives up anything, except the idea that you might one day push the others off the islands that they currently occupy. And you just accept and ratify the status quo. That seems to be the sort of the least difficult way to some motive end in the South China Sea.
And I have to ask you this, although I was going to let you go there. Would that not set a bad precedent, given the debate that's now going on about status quo in Ukraine and issues like that? A bad precedent of international law, if such a thing exists?
Well, let's see what happens in Ukraine. It may well be that people decide on a temporary de facto recognition of occupations as a prelude to something else, in the same way that the Korean conflict has been frozen for 70 odd years.
Yeah, so you can actually freeze the conflict or take the heat out of the conflict, and therefore it goes away for a bit, half a century or something. Bill Hayton, thank you very much. Stay around, because I'm going to bring you and your expertise back in again. Our next speaker is Dr. Nong Hong, Executive Director and Senior Fellow at the Institute for China-American Studies in Washington, D.C., also a Senior Fellow at China's National Institute for South China Sea Studies. Her publications include China's role in the Arctic and, most recently, US-China global maritime relations. She is going to sprinkle into our debate a touch of the Chinese perspective. Is Bill Hayton's history right or wrong? Dr. Nong Hong, give us your argument.
Well, thank you, Humphrey. As I explained to Mr. Bruce when I was invited, so my intention is not to reiterate China's policy and strategy as a counter argument, because I think this topic has been widely, extensively covered. But I was happy to answer that question during the Q&A, because it would be short and it could be long. So I think my intention is I'm trying to bring to the discussion, instead of covering only on China, I want to share with you as a research on the South China for more than 20 years, what has been changed and what has remained unchanged. Hopefully, through my very brief discussion, will explain why we are caught up in the situation today. So I want to focus on 4 elements that I consider what has changed. So we look at the past 20 years as well, when the discussion on the South China Sea primarily center around the respective claimant states, including all the claimant states and ASEAN-China relations, and the role of external users such as the United States and also some European countries who are exercising freedom navigation. And however, today, when we're looking to the narrative and the discourse, the dynamic has shifted significantly. So we're talking mostly about how the U.S.-China interact with each other in the South China Sea. And they actually form 2 broad interest groups, one representing the coastal states and the other represented usual states. So, and the other change I can define is the center of focus of discussion has been changed. In the past, the discussion include a wide range of issues, including territorial disputes, as Bill just mentioned, the fishing conflict, and the search and rescue, maritime cooperation, the U-shaped line, etc., etc. And we talk a lot about maritime cooperation and joint development as well. But nowadays, those discussions actually consider all the claimant states. However, if we look at today, the focus narrowed down to, for instance, we talk about arbitration, Coast Guard activity, gray zone, law enforcement, and with a disproportionate attention directed at China. And the third element that I consider has a significant change is the legal development. In the previous years, when we talk about legal issues in the South China Sea, we mainly focus on the status of the U-shaped line, as Bill just mentioned, and other debatable questions are the military activities in the foreign countries, EEZ, whether they enjoy the same freedom navigation as high sea. And we also talk about the island or rocks and also their legal status, where they are entitled to 200 nautical miles EEZ or they're only entitled to 12 nautical miles territorial sea. But currently, when we refer to the legal debate, as Mr. Bush mentioned in his opening remark, mostly we are talking about the 2016 arbitration between the Philippines and China. And then my understanding is that we probably will hear a lot of legal issue lately. For instance, the submissions to the UN Committee on the Extended Canal Shelf. And then we also hear about the most recent announcement or a report that the Philippines is going to initiate the second arbitration in terms of environmental issue in the South China Sea. So my understanding is that as a lawyer on international law, I see this change illustrate how international law is being increasingly used as a tool for diplomatic maneuvering and strategic positioning. And the fourth element on what has changed is the relation among the claimant states. So despite the ongoing territorial and maritime dispute, the past decades, we saw continuous negotiation and discussion on cooperation and claimant states. And ASEAN centrality was a guiding principle, and diplomatic negotiation were never abandoned. However, today, a question I want to ask whether ASEAN centrality is being questioned, because we hear different divergent and different interests among the states, whether they are claimant of the South China Sea or they are not. So we witness increasing unilateral action in the South China Sea, such as in gas and oil exploration and overlapping areas. And we also here witness the reinforcement of many occupied features and unoccupied features, which reflect a shift towards assertion and expansion of rights rather than cooperated management of disputes. And then what has not changed? I would like to say the dispute still remain unchanged. The territorial dispute remains unresolved, and the maritime delimitation still pending. And then also the willingness to cooperate, I believe, has not changed, although we hear a lot of conflict and debates. But I think all the claimant states are willing to cooperate, are willing to solve the issue or calm down the competition. But there are concerns about the potential accident at sea. They continue to shape the regional security calculation. And also what has not changed, we see very positive national legislation, which continue to be adapted to align with international law. And I don't know whether everyone is aware, even though there's a lot of issues in the South China Sea, but I think every claimant state, they're trying very hard, for instance, to pass along many of legislation, including their efforts related to the establishment of marine protected areas and their participation in the international negotiation like BBNJ, the High Sea Treaty negotiation. And those reflect the interaction between the environmental governance and geopolitical competition. And then I would like to also emphasize two issues on the current debates. One is on the China-Philippine relations. We heard a lot, or too many, through the media, through analytical studies. So the ongoing dispute between China and the Philippines is increasing from in terms of international public opinion. Let me put it this way. The Philippines has very strategically positioned itself as a smaller state seeking international support, left the legal mechanism and public diplomacy. I think in this sense, its goal has succeeded. And there is, however, if we talk about the China-Philippine relation and the conflicts, particularly on fishing conflict, it's not a new phenomenon. We hear a lot of fishing conflict for instance, back in 2006, there was a Philippine fisher boat intrude into China's Nansha Island, resulting in the death of several Chinese fishermen. We hear a lot, not only between China and Philippines, among all the claimant states. However, those incidents were previously addressed through bilateral discussion rather than international litigation. And the second issue in terms of current debate is a legal issue. There are two legal debates I would like to share my views. The one is the state consent in the dispute settlements. There is a reason we hear a lot why China is not willing or decide not to participate in the arbitration initiative by the Philippines under arbitration under Annex 7 of UNCLOS. So I'm not going to detail because it's going to take a long time to explain the jurisdiction admissibility issue, but it's just one principle. Under international, states have their sovereign rights to choose the means of dispute resolution, and one of the many key important is the state consent. Without state consent, we will not be able to resolve the issue which is designed by the principle and the spirit of UNCLOS. And the other debatable issue in terms of legal is the treaty law and customary international law, and there's growing divergence in how the claimant state interpret the treaty-based obligation versus customary international law, which continue to shape the legal contestation. So let me put China's case to explain why the treaty law and customary international law make sense. Let me put China's policy in the South China Sea in 3 very brief sentences. China claims the territory of the features within the Euphrates based on customary international law, such as administration, occupation, and acquisition of territory. And then, because it ratified the Law of Sea Convention in 1986, then it also claimed it is an international shelf and other maritime rights within the South China Sea based on the UNCLOS. However, because the UNCLOS does not provide other customary international law, which are not listed in many of the provision on the UNCLOS itself, but it recognized the under customary law. That is why China relies its historical rights assertion based on customary international law. And the question is how we actually find a balance between the treaty law and customary international law. And I think that's the thing I want to respond from a Chinese perspective. And then there is the third debate on China and the emerging coalition. For instance, we see the current debates not only about China and ASEAN, not about China, Philippines, China, Vietnam. It's all about, suddenly we have all this coalition led by the US, for instance, UNCLOS Squad, all these external states. I recognize the legitimate inter-freedom navigation, but the forming of like small allies, emerging coalition, and that actually bring uncertainty in the security and the ongoing stability in the South China Sea. So my final 2 points, I think how to move forward. There are two pair of relations I think that it's very important to maintain. One is the US-China relations, although their status in the South China Sea is different. China is a coastal state and the US is a stakeholder. But at the core of the US-China maritime rivalry is it's actually about the power distribution rather than the dispute over the sovereignty or over the free navigation. And to maintain the stability, I think both states must work towards reaching a mutually recognized set of rules, a maritime order that's recognized not only by China and the United States, but also by the broader international community. I think that's very important. And the second pair of relation is among the claimant states. So beyond the US-China dynamic, how to manage the relationship among claimants is equally crucial. I think all the claimant states in the South China Sea, they are trying very hard to maintain either bilateral relations or regional order, even though we hear a lot, for instance, the dispute between China and the Philippines. But I do believe all these countries, they have willingness to cooperate, and given their territorial and maritime disputes, and also strengthening the ASEAN mechanisms, ensuring the bilateral, multilateral negotiation, and advancing cooperative initiative in a lot of areas, including fishing management, environment protection, and scientific research. They can actually help mitigate the tensions. So I'm going to stop here. So Humphrey, I know that you want me to talk about Chinese perspective, but I can respond when we hear more from other colleagues. I'm pretty sure when I look at all these titles, I think they're more than history, right, that we'll be discussing.
Oh, that was fascinating. I just wanted to, if you can give me a quick answer to a couple of points. How close is you've envisaged a solution and a way forward. How close are you to Bill Hayton, which is basically, I think, Bill, is to shrink the 9-dash line and then have an agreement on that status quo there. How close are you to that?
How close? Or I should say, okay, there are two steps. First of all, we have to bring all the historian and archive to look at the whole picture of the historical records. And I believe that Bill has presented to a couple of maps. I'm not a historian, so I cannot actually make a conclusion whether they are comprehensive. I will suggest, to answer this question, you have to convince China, you have to convince Vietnam, because Vietnam also have their historic claims, whether those archives, they are comprehensive. We have to compare all the maps collected by all the individual countries. And I believe China's government, they also have collected many maps. We have to bring together those historians to compare.
Sorry, are the maps relevant now, given that international law seems to be a fluid element in global politics now? Are the maps relevant, or could that just be a deal struck?
I think, as I mentioned, I'm not a historian, but I think I can recommend to you a book or article by Irish historian, international law. It's written by Professor Anthony Cuddy on the Archives of International Law. So my point is that it's not one sentence to convince, well, we should give up this. First of all, we have to make sure everyone on the same page. But I believe Bill's roadmap, I think he made a very good point, because right now in the South China Sea, it's not only about the history, it's not only about law, it's also about nationalisms and how the local people, how the domestic, they look at the decades situation. And then how close? As I mentioned, you have to bring all the stakeholders on board, and it's difficult. I have to admit, it's difficult given that different countries they have their different national interests. Yeah.
Yeah. And before I let you, can I just ground something here? There has been no, as far as I can remember, disturbance to shipping traffic through the South China Sea throughout the whole of this thing, unlike, say, in the Gulf of the Middle East, where ships are now having to go around the Cape because of the Houthi rocket attacks.
Oh, the answer is no.
Is that correct?
I don't think there's any obstacle in terms of commercial shipping in the South China Sea. We never heard about it. We probably will hear about like accident because the weather, but we never heard about the commercial shipping has been hampered.
So the free flow of trade has continued unabated despite all this debate. Thank you so much for that. Don't go away because we're going to want your expertise back again. We are now going to India. Dr. Pooja Bhatt, Associate Professor at the Jindal School of International Affairs in India and Visiting Fellow at the Stimson Center in Washington, D.C., where she is not at the moment. She is an expert on India's naval and air power and is author of a book, 9-Line, Deciphering the South China Sea Conundrum, which is exactly what we're here for. What is her interpretation of the 9-Line and why does it matter? Dr. Pooja Bhatt, give us your argument.
Thank you, Humphrey and Democracy Forum for having me today. So after following Bill and Dr. Nong, I'm neither a historian nor a lawyer, so I'm a strategy expert. So what I've tried to decipher in my work on South China Sea is the strategy aspect of it. That there were two crucial questions that my work wanted to find out: that why is South China Sea important for China? And second, what will be the regional and global ramifications of Chinese aggressiveness and its military aggressiveness in South China Sea? And with these two questions, India as an extra-regional power, how do we see from India the entire region? So in this regard, what I tried to do in my work in the book and work further on was divide China's approach towards South China Sea into different verticals: a history, legal, military, environmental, political, and economic, and try to see that how in each of the vertical, the idea of South China Sea plays a crucial role for Chinese own development, and deriving a lot of work from the strategy documents globally, the historical documents and the books coming from China and from other experts. So I've derived a lot of work from them also, as well as the primary sources. And in that regard, I realized that it has been always the Chinese aspiration to be a global power, to revive that position of a global power again. And in that regard, to become this global power, South China Sea remains crucial, central for China. We have spoken about certain aspects in history and legal claims, where the century of humiliation was one thing with which China still, for the longest time, carried its humiliation of defeat through its maritime domain. So that history, China doesn't want to repeat that kind of history again. That's why it has this kind of military presence in the South China Sea to protect its backyard from its adversaries. On the other hand, then we see the legal claims, and some of it Bill and Dr. Nong both have discussed that how legal interpretations of different legal connotations, historical names have actually played a huge role in this. US presence militarily in the region has also ignited the entire debate about why China also want to remain present in the region, because there are US bases as well as the freedom of navigation operations that US does there regularly. So that has also threatened China a lot. Similarly, in economic side, the South China Sea is considered as good as second Persian Gulf, and the kind of minerals and the oil and gas exploration opportunities which are present there. We can always see these incidents happening in South China Sea, and we can relate that to how economically South China Sea is important. So in a way, in short, I would want to say that South China Sea is heart for China's rise to power globally, and therefore we will not see any let go of these kind of efforts from China. What has happened in past few years and as the implications of South China Sea dispute? One is as India's own position, that as India, we would not bother too much about South China Sea till recently because we never thought South China Sea has an implication for us. But now we see, as much as we have growing trade in that region and also our approach toward the global commons, South China Sea is again becoming very crucial because whatever happens in South China Sea has a direct implication in Indian Ocean, and we are located there. And similar, I think it's true with other countries. On the other hand, we have also seen Chinese position on entire 9-line shifting from entire waters of South China Sea, and that's why we were discussing that the commercial trade is not hampered when this is in South China Sea. What get hampered is the warships, and if they're trying to cross any of the islands which China tries to claim on its own. But the statements have shifted from relevant waters to now we hear that what recent Chinese statements coming that the particular country has come to Chinese territory. So now it's other way around. At the same time, we have seen increasing aggression in the recent times from China, and there is also reciprocity in that aggression from the other countries like Philippines and Vietnam, where they're pushing back on Chinese claims, both militarily and informationally, and if you see the documents they are producing. So that is one of the implications of this kind of development. And lastly, the domestic maps that China has been producing. We have seen that there has been no let go of China producing these certain kind of maps where they continue to name and rename certain areas in South China Sea and beyond in its own under its own jurisdiction and rename them, and that's been slowly and gradually happening. So there is no let go of that. So in conclusion, I would want to say that whatever's happening in South China Sea, we will not see any letting go of that. China will not forego its claim on South China Sea because it's so crucial for its own rise to power concept, which is very deeply entrenched in the Chinese constitution now. Second is most countries might be compelled to sign any joint exploration with China in terms of what we're seeing with Philippines and Vietnam, where China would want to resolve the issues by asking them to sign joint exploration of resources, and we can discuss why it would be happening. And lastly, it will remain difficult for extra-regional stakeholders, and I would call us stakeholders because we have stakes in terms of economic trade and as well as the global common interest. It will remain a difficult region for the rest of the world, and it's very difficult. It will not be only China and its neighboring countries issue. It will have a global ramifications. And with that, I'll stop.
Dr. Pooja Bhatt for that. Can I put a question from the audience that's come in from Funsakya? You've answered it in a way, but let's look at it in more detail. Can the 9-line carry any legal weight when the PRC has never really explained what this dashed line signifies?
No. Simple answer is no. It's never been explained anywhere by China, and it's a term which everyone is using without any proper justifications. I don't think so. There's any legal.
So the legality that we're discussing in this debate refers to the territory and not the dashed line.
Correct.
Yeah. And then Ritesh Nigam says, why did China, if you can attempt to answer this, why did China embrace UNCLOS if it threatened its own position in the South China Sea?
So I think it was, in a way, a leeway provided by UNCLOS that China used it in its favor. So under one of the articles in one of the sections, it provides for those countries to have an escape from certain provisions of the UNCLOS, and China used that clause to escape itself from the 9-line jurisdiction. So I think China has used UNCLOS in its favor where it suited it.
Okay, so it's used in its favor. And just one last one, given that you are in India and there's the Indian Ocean, the ruling against Britain in its Indian Ocean territory, which is becoming a bit of a political dispute across the Atlantic and here in Britain as to whether we should abide by that ruling or not. Where does that sit with all these legal disputes in the South China Sea?
Yes, now that's a matter of a country standing. Unlike China, which that considers as historical rights because of the names, and as Dr. Nong has said, Britain may use a different way of approaching it. They can always say that yes, now the island's no longer completely theirs, and they can have a settlement on that issue. But it's again on a country's position and how they want to resolve this issue.
Yes, so in this case, although the two legal judgments, one was apparently binding, one wasn't, but there was no means of enforcement, the debate here in Britain as to whether Britain should abide by international law or not, and that's the debate in the United States. But over the past couple of decades with China, we have been insisting that it does abide by international law. Sitting in India with your multipolar hat on, how do you see that situation?
I would, for me as a scholar, I think setting a good precedence in this regard would be very helpful. Like India did this with Bangladesh when we had recently resolved our maritime border dispute within Bangladesh, where we lost a considerable amount of EEZ. But it was for establishment of good order at sea, and also to improve your maritime relations with your neighbors. So I think if India can do it, I think UK could do it, and I think China also can do.
Thank you very much. That's very useful to spur on our debate. Our next speaker, our penultimate panelist, is Dr. Collin Koh, Senior Fellow at the Institute of Defence and Strategic Studies at S. Rajaratnam School of International Studies. He's widely published, and his research specializes on naval issues within the Indo-Pacific, specifically on Southeast Asia, which are those countries impacted by the South China Sea claims: Philippines, Indonesia, Malaysia, Vietnam. Dr. Collin Koh, share your insight.
Great. I hope you can hear me. Firstly, many thanks, Humphrey, for your very kind introduction, and a very good evening from Singapore. I'm actually loading up my slides, but in the event that it doesn't get through, I will just speak off the cuff. First of all, let me just thank the Democracy Forum for inviting me. It's a great honor to be here, and not least because I see all my friends here. So it is great to actually come together to talk about very topical issue. Firstly, I have to stress that I am not, just simply going to talk about the entire Southeast Asia. I don't claim to be representing the whole Southeast Asia. If we just consider the ASEAN member states, there are 10 of them. And of course, I'm going to present as my slide here, which successfully popped up now, as it highlights, it's just a Southeast Asian perspective. And of course, I'm not going to claim to represent the views from Singapore as well. So let me just run through very briefly what I'm going to talk about. So earlier, our friends here, Bill, Nong Hong, and Pooja had run through some of the very salient points when it comes to the South China Sea legal and geopolitical aspects. I'm going to just briefly give a rundown on Southeast Asia. First, in general, if we talk about anything that comes with consensus on ASEAN, and ASEAN works by the principle of consensus, the 10 member states, they will have consensus when it comes to the very general issue about good order at sea. They will agree that there is need for freedom of navigation and overflight. They agree that there's a need to resolve the disputes peacefully without the threat or use of force. But beyond that, ASEAN as a 10-member institution does not take any side when it comes to the merits of the dispute itself. And the problem with having such a large organization is if you consider there are 10 countries and not all of them have a South China Sea seaboard, and some of them are considered relatively landlocked. In this case, Laos is landlocked. Some of them clearly have no clear interest on the South China Sea. So it's very difficult sometimes for those countries to come together to have anything that goes beyond the generalities that I just highlighted earlier, freedom of navigation, overflight, non-trial use of force. These are very general. But by and large, on the whole, individual Southeast Asian parties to the South China Sea, and by that I mean those who are claimants and those that are non-professed claimants. For example, the unique case of Indonesia that is a professed non-claimant, even though it has some overlapping waters with China in that regard. So in this case, it's very difficult to have anything that resembles an agreement on the ASEAN level that could be brought to the table with China to resolve as a multilateral dispute. So very much the position is that when it comes to management of the South China Sea dispute within ASEAN, they are talking about management of the dispute itself, meaning we're talking about conflict prevention, practical security cooperation. But when it comes to resolving the dispute, I don't see any Southeast Asian country actually agreeing with a multilateral approach. And in that sense, their philosophy appears to align more closely with China's. And other than that, another thing that we really need to note is when it comes to interpretation of UNCLOS itself. And much has been talked about China, of course, but if you look at the statements and the official policies of some of the ASEAN member states, you'll find that the way they interpret UNCLOS when it comes to the freedoms and the rights of user states through their waters, some of them do align more closely with the interpretations by China itself. So in that sense, this complicates the discussion on the South China Sea. So with that as the general backdrop, let me just run through 3 case studies. I'm going to just survey through the latest developments so far using 3 select case studies in Southeast Asia. Of course, the first is Indonesia, but let me just point out that if you put China out of the picture and just consider for a while, for the sake of discussion, that the South China Sea just merely concerning Southeast Asian countries, maybe you might not have so much a very complicated issue, because in this case, in the recent times, some of the Southeast Asian parties to the South China Sea, given that they have intra-ASEAN disputes amongst themselves, they were able to demonstrate that they are able to actually reach some form of agreement of some sort. This is the December 2022 agreement between Indonesia and Vietnam on the EEZ delimitation. It is a multi-year negotiation that they have engaged in for a long time, and finally they sort of get through that. It's one thing about signing on the document, but what I hear from the ground is that when it comes to enforcement, implementation, it could be problematic, but at least they got something on paper. However, if you include China into the picture, it does appear that the situation becomes a little bit more complex and complicated when it comes to the strategic calculus of the various Southeast Asian countries, in this case, Indonesia. This is a very interesting case study because prior to that, Indonesia has barely, made noises when it comes to the South China Sea, when it comes to China. One key reason has been the economic relationship between the two. And the one time that Indonesia actually made it very public about China's incursions into its EEZ was last year, October. And that was on the very day of the current president's inauguration. This was the first time that such incursion was publicized, even though such incursion has been taking place for many times. So the reason why this was being publicized is more because the Prabowo administration, or more accurately, the president himself, doesn't want to be seen as weak on the very day he was inaugurated. So he wanted to send a signal to China. When everybody was thinking that Prabowo has taken on a tough stance against China, what happened the month after came across as anything less than shocking. Is the agreement that was signed between Indonesia and China in the joint statement that followed the meeting between Prabowo and Chinese leader Xi Jinping, and in which one key mention was particularly surprising to observers, including myself. As you can see, this is a screenshot of the agreement, and this was the highlighted part where they talk about areas of overlapping claims. This was the very first time that Indonesia publicly acknowledged that there is an overlapping claim with China, even though the long-standing position of Indonesia is that there aren't any overlapping claims. What was happening was that the Prabowo administration decided to proceed with the joint statement with the wording without consultation with the Attorney General chambers as well as the Ministry of Foreign Affairs. So therefore, it is purely his inner circle's work, and he sidelined the other important agencies. When this came out, it created a huge uproar, not just outside Indonesia, but more importantly within Indonesia, that in a way undermines Prabowo's legitimacy, because he wants to portray himself as a strongman. Then this joint statement seems to undermine that very objective. So he sort of wrote back. He did not make any further statement to that, but he left the Ministry of Foreign Affairs to clarify that there is no change in the position. But the joint statement as presented here is a done deal, and China is thereby going with that joint statement and taking his word for real. The other country that was interesting in lately was that Vietnam has recently come to the fore, and I believe there are recent studies, especially the one that's done by AMTI regarding Vietnam's construction and island building activities in the South China Sea. And Vietnam, until recently, this position has been sort of taken over by the Philippines since 2023, that position of being the most vocal amongst all the Southeast Asian parties, it is no longer that vocal. It is still maintaining the patrols against China. The last clash between Vietnamese and Chinese forces revolved around the Hayang Shiyu 981 Oryx incident back in 2014. That was more than 10 years ago. Since then, the two countries have agreed to so-called properly manage that dispute. If you look at the bilateral joint statements that come about ever since then, they've always have these pretty cryptic mention. They talk about properly managing dispute. And that appears to mean that Vietnam and China will do whatever they need to do, and they are not supposed to interfere with each other's activities. At the same time, they will try their best not to let all these issues go onto the media limelight. So in a way, it is to keep a low profile of what they are doing and not name and shame each other. And for Vietnam, I think some lessons are pretty clear. I think one thing to note is that since COVID-19, Vietnam has increasingly relied on China on various economic goods. And I think the most important has been agricultural exports. If you have seen the latest figure, is Vietnam actually had a whooping more than $5 billion fruit exports, and much of it went to China last year. So that is a huge market. And this picture that I show here was a potential problem that Vietnam tended to face. And that was some years ago when China suddenly will clamp down on the customs and quarantine regulations, and all you will find will be Vietnamese trucks carrying the perishable agricultural product being stuck at the border gate. They can't go through, and they are spoiled, and it created huge losses on the Vietnamese agricultural sector. So this was one key lesson Vietnam has learned. It has been trying to diversify economically to other markets, but so far it has not yet yielded the result that will allow Vietnam to completely wean off the Chinese export market. And so therefore, what we are looking at here is Vietnam is looking elsewhere, is still doing what is doing in the South China Sea, but despite its very vocal position against China in the past, Vietnam right now appears to try to lie low, and at the same time is still engaging other extra-regional parties to try to bolster its position in the South China Sea vis-a-vis China. The last example I want to show is a most recent one. Of course, some will argue the more extreme type example, which is something that come across as quite an anomaly in Southeast Asia, where you have countries that will adopt on a more consistent basis a megaphone diplomacy against another disputant. In this case, the Philippines, with its assertive transparency strategy, it has been highlighting, publicizing China's behavior in the South China Sea. But all that actually were brought into question when all these transparency initiatives were not actually improving the situation, according to some commentators. In fact, if anything, some argued that this approach led to the clash last June between China and the Philippines around Second Thomas Shore, and making people wonder whether this is all worth the effort. Of course, it didn't end with that. 1 month later, there was another clash at Sabina Shore, and thereby led to questions as to whether this is the type of strategy that Southeast Asian countries ought to actually adopt going forward. It does appear, based on what I hear late last year in Manila, we had a very interesting South China Sea dialogue. And during one of the panel discussion, some of the Southeast Asian Coast Guard representatives were there, and this question was being posed to them as to whether they will be willing to adopt something quite similar to what Manila is doing. And we hear kind of a sort of willy-nilly amongst them. They are not too keen. They are also quite interested and open to the idea. They are not too sure, perhaps because at the highest political level, that is where the decisions are made, and they aren't in any position to say anything. But it does appear that going forward, it is not possible for some of these countries to adopt what the Philippines is doing, even though they are watching. But one thing to note before I end off is that if anyone will argue that this Philippine strategy is actually undermining the Philippines as a whole because it does affect trade with China, it does appear that based on the results and the statistics that are collected over a period of time, and in this case presented here is China as a percentage of total exports by the Philippines. Until late last year, there isn't any conclusive evidence to show that there is any impact on Philippines exports to China. At the same time, if you look at the broader statistics, the Philippines has actually reduced its dependence on China somewhat to a degree. So the efficacy of this strategy might be something for Southeast Asian countries to look into. And with that, I will end off here. And thanks, Humphrey. I will be happy to listen to any questions from you.
Collin Koh, thank you very much for that fascinating detail there. Just very quickly, you said right at the beginning that the philosophy of Southeast Asia was more closely knit to China. Can you just tease that out a little bit? What did you mean by that?
I think it will be interesting to look at, for example, the passage rights of user states. By users, I mean anyone other than the coastal states using those waters, such as Territorial Sea and the EEZ, for example. Some of them have the position that if any foreign country is going to transit through their territorial sea, and by that I mean government ships like warships, for example, they are supposed to seek permission or give advance notification. And this is a position that aligns quite closely with what China has. This is just one type. The other type will be in the EEZ when it comes to foreign military activities, the conduct of military exercises, whether that requires permission or not require permission. In the EEZ, this is somewhat nebulous because there are differing interpretations as to whether user states ought to notify based on the very premise of so-called due regard. So if it is in due regard to the coastal states, for example, and if everything has been done with that due regard in mind, then there's no need to even give any notification. However, some Southeast Asian countries require notification and some require permission to conduct such activities. So that's what I'm referring to as to the alignment. Yeah.
Thank you. That's very interesting. Our final panelist is Gregory Poling, Director and Senior Fellow at the Southeast Asia Program and Asia Maritime Transparency Initiative at the Center for Strategic and International Studies in Washington. He is sitting in the heart of the new America, and among his many talents and skills over the past decades has been the Island Tracker, which discovers which country is building what islands where. His latest book is On Dangerous Ground, America's Century in the South China Sea. Greg Poling, you've heard the arguments. You are deeply knowledgeable on this topic. Share your thoughts.
Thank you, Humphrey. And I'll echo Collin's point. It's good to spend this time with all of my friends. I think all five of us have had these debates at who knows how many conferences over the last decade or more. Let me open, I guess, where I have to as the American on the panel on U.S. interests and why the U.S. has been so engaged in the South China Sea, particularly over the last decade. And then I'll hit a couple of quick points raised by some of the other speakers. So the U.S., as Nong pointed out, is not a coastal state in the South China Sea. The U.S. is as Pooja mentioned for India, a user state. It's an interested party. This is the busiest shipping lane on Earth. It is available for passage by all states. It is a global maritime commons, like most of the oceans, and it touches directly on core U.S. national interests in a couple of ways. And these have been very consistent. If we go back and look at U.S. government statements about the South China Sea, at least since the mid-90s, when China really became more assertive in the area, the U.S. talking points have been extremely consistent. The U.S. cares about freedom of the seas, meaning that not only the U.S. Navy is able to operate freely in the South China Sea, but that the rules are observed and that there are rules, whether those are customary international law or the rules embedded in the UN Convention on the Law of the Sea. Second, the U.S. cares that the disputes are resolved peacefully, and that particularly means no use of force towards the Philippines, the oldest U.S. treaty ally in Asia. So the U.S. has a very immediate stake in deterring aggression toward the Philippines and responding on behalf of the Philippines if there was aggression. And then finally, the U.S. remains neutral on issues of territorial sovereignty. And this has become a point of contention with China. Chinese academics and officials will often say that the U.S. is not, in fact, neutral because the U.S. backs the Philippines and, to a degree, other Southeast Asian claimants over China. And the U.S.'s response is, look, we never said that we were neutral about the rules. We never said we were neutral on whether or not China can claim 1,000 miles of water when every other country on Earth only gets 200. The U.S. is neutral on who ultimately has sovereignty over the islands. But the U.S. has a very clear position on the nature of the maritime claims. You cannot claim waters, seabed, and airspace beyond that allowed by international law. You are welcome to argue in perpetuity over which reef belongs to China or which rock belongs to Vietnam. So that's been the U.S. position. And what has elevated the issue in U.S. strategic thinking has been the steady expansion of the nature of China's claims, because China's claims have very much changed over the last 30 years. It started as a claim to rocks, and it has now become a claim to ill-defined historic rights everywhere in the 9-dash line. And two, China's military modernization, which allowed it to actually operate in these waters that it had claimed for decades for the first time, paired with the more risk-taking and aggressive nature of the Xi Jinping government in its pursuit of its maritime claims. China using coercion and threats of force against its neighbors in ways that previous Chinese governments never did. So that is why the U.S. cares about the South China Sea. I'll also say I'm very well aware, as you said, Humphrey, I'm sitting here in the heart of what you term the new America. That makes the U.S. position on things like international law in need of defense, and I'm happy to take that up more directly in Q&A. A few other points, though, before we get there. One, I think we have to, as Collin did, note that this is not a bilateral U.S.-China dispute. It's not an issue just about China. Too often, even within Southeast Asia, discussions about the South China Sea revolve almost entirely around China or the U.S.-China dynamic. And that ignores the fact that there are more than 550 million people living in Indonesia, the Philippines, Vietnam, Malaysia, and Brunei, who also have a direct national stake here and who are the ones actually suffering, who miss out on the opportunities presented by access to natural resources and the like in their exclusive economic zones. We also spend, I think, far too much time discussing just the historical merits of China's claims. And Bill did an excellent job of pointing out how China's claims are actually quite new in almost all cases. But the Vietnamese have just as valid, if not stronger, claims to the Paracel Islands dating back to the early 19th century before French colonization. The Philippines can pull out document after document showing that even during the Commonwealth period of home rule under the Americans, they were already actively claiming Scarborough Shoal and the Spratlys long before China ever did. So this is not a case, as China would often present it, of an ancient Chinese claim that has suddenly, over the last, say, 50 years, been challenged by Southeast Asian claimants because of UNCLOS. No, these are multiple, usually relatively weak historical claims to islands that are largely irreconcilable, and then a more modern dispute over airspace, seabeds, and waters that's really about the rules of the international system, or whether or not there are any rules. On that point, the large outlines of a regime to manage these disputes, not necessarily resolve them, because trying to figure out sovereignty over each rock and island could take decades in arbitration or negotiation. But to manage the resources and manage the rules around things like passage and military activity, etc., the outlines of that settlement have been well defined since at least the late 1990s. All of the Southeast Asian claimants, as well as the other members of ASEAN who are not claimants, and the outside parties like the US, like the UK, like Australia, Japan, India, who have voiced opinions on this, all of them agree that claims must be made within the context of UNCLOS, that resources within the exclusive economic zone of each state are exclusively that state's. Joint development can happen in international waters, that you can find creative things on issues like fisheries management where UNCLOS allows these. This has all been written or argued about in the ASEAN-China Code of Conduct process that started in 1998. ASEAN together presented a outline of a settlement to China in 1998, which was written by the Philippines and endorsed by all the rest of ASEAN. And that settlement is still out there. China refused to bend on any of the core issues within that document, which eventually led to the non-binding declaration on the conduct of parties in 2002 when ASEAN gave up. They've been trying to renegotiate a code of conduct now for the last 23 years with no progress. And at the heart of the dispute is the fact that China insists on historic rights everywhere in the 9-dash line. That China, uniquely among all the nations of the earth, is entitled to 1,000 miles of water when everybody else gets 200. All of the other disputes that happen between the Southeast Asian claimants are happening within the context of international law, right? They're about interpretations of the rules or about where exactly a line should go in the context of delimitation. China's claims present a larger question: are there rules at all? Or do big countries even have to pay attention to rules if there are? And this gets to almost a philosophical difference, and one that defies clever negotiation. All the other claimants of the South China Sea operate within a context, within a conceptual framework that says that international law is universal and legally binding. Of course, there are different interpretations, things have to be renegotiated, but the law applies to all states equally, big or small. China's position is that international law, very similar to domestic law in China, is contingent, it is malleable, particularly to the needs of those in power. It is a tool for the exercise of force and the exercise of power. It is a system of rule by law, not rule of law. And therefore, the rules applied to China when China was smaller and weaker, and the rules need not apply to China anymore now that it is a rising great power. And finally, I want to close on a point that Collin just made about the Philippines. I just got back from Manila about a week ago. I was also with Collin in Manila last year. While the Philippines has certainly, I think, evinced a lot of criticism and concern among other Southeast Asian claimants because of its more assertive position in the last 2.5 years under the government of President Marcos Jr., the Philippines views its own strategy over the last 2 years as having been quite successful. In the case of Second Thomas Shoal, where we had those very dangerous standoffs with China that led to the June 17th incident where Chinese soldiers severed the thumb of a Filipino sailor last year, that all revolved around Philippine efforts to repair the ship that they have grounded at that shoal, the BRP Sierra Madre, and China's efforts to stop that. They were able to de-escalate and negotiate a provisional arrangement after that June 17th incident precisely because the Philippines had succeeded in repairing the ship. So from the Philippines' point of view, that was a tactical Philippine success. And China, despite using hundreds of vessels at times and quite a lot of aggression, had failed to prevent Philippine resupply. And then stepping back strategically, the Philippines views the transparency effort that surrounded that and the diplomatic push behind it as remarkably successful. It led to a renaissance in the U.S.-Philippine alliance, the Philippines' rapid military modernization. It has galvanized public support within the Philippines on the South China Sea, and it has created a Philippines that is now more embedded in regional alliance and security networks. The Philippines has negotiated a new access agreement with Japan, plans to ink new agreements with New Zealand, Canada, France, and Germany by the end of the year. The Philippines views itself as no longer standing alone. And that is how ASEAN left it feeling. The Philippines felt that ASEAN had abandoned it, and it is now finding support abroad in ways that are more useful to it. And with that, I look forward to questions.
Thank you very much for that. Can I just nail a couple of things with you? We talked about the freedom of shipping has not been interrupted. That's that free flow. So compared to, say, European waters and Middle Eastern waters, the South China Sea or Asian waters are comparatively calm at the moment.
If you are an international container ship or an LNG tanker, if you're a Filipino fisher or a Malaysian survey ship or a Vietnamese Coast Guard vessel, that's not the case at all. You're still out there getting rammed, water cannoned, intentional threats of collision caused by Chinese vessels, which is why you see the U.S., particularly over the last 8 years or so, focusing on terms like freedom of the seas or saying freedom of navigation and other lawful uses of the sea. Because when we talk about freedom of navigation, too often we only think about international traffic. Right. UNCLOS, most vessels on the sea are not international shippers and they're not Navy ships, they're fishermen. Yeah. And those are the ones who are losing their livelihoods to Chinese aggression.
And how carefully choreographed or not, or how dangerous are the freedom of navigation, the military testing of Chinese resolve there or vice versa?
U.S. freedom of navigation operations, which is a kind of a uniquely U.S. thing, but a lot of countries do things that we would think of as FONOPs, particularly over the last couple of years in the Strait of Taiwan. Those have become pretty regularized and normalized. I mean, they happen more frequently today than they did, say, during the Obama administration, but you hear far less about it. And that's because U.S. and Chinese vessels, for the most part, and those of other states, operate quite professionally, and we don't really complain about it because there's no value to elevating it into the public domain. What has remained quite dangerous, though, are two things. One, China has become far more aggressive in the harassment of air operations. There was a negotiation between then President Biden and President Xi when they met on the sidelines of APEC that negotiated a decrease in the frequency of Chinese unsafe air intercepts of American aircraft. But Chinese aircraft still very aggressively harass Australian and Canadian aircraft. Just last week, they released chaff into the rotors of a Australian aircraft. That's the kind of thing that could lead to an unintentional, death, and then put us into a real crisis.
Thank you for that. I want to go around now, starting with Bill again, and go around as we started with a question from the audience. Philip Bowman asks, what is the likelihood that regional cooperation of China and the ASEAN countries can thrash out a workable binding code of conduct for parties in the South China Sea? Bill did touch on that, but because we have legality in the title of our debate, I want to go to something that Greg talked about, that within Southeast Asia, law is seen as universal and binding, but in China, it's seen as a tool of the exercise of power. And please give us, all of you, your view on what it's seen now in the United States. Bill.
My favorite question, the code of conduct. The answer is basically it's not going to happen, but that doesn't mean it's not worth trying. For the ASEAN countries, the Southeast Asians, they see the code of conduct as trying to bind China's behavior. For China, it sees the code of conduct as trying to bind America's behavior because it wants to put things in the code of conduct like you can't have a military exercise with an outside country. You can't do an oil deal or a gas deal with an outside country without the permission of everybody, i.e. China. So those are the basic problems. And then the actual details, China only wants to talk about the Spratlys. Vietnam wants to talk about the Paracels and Scar Shoal. Some countries in Southeast Asia want the POC legally binding, whatever that means. China doesn't. So the same issues keep coming round and round and round and round. They have done for 25 years, and they'll probably keep doing for another 25 years.
And is it better that they keep going round and round, that actually somebody tries to push through a deal that could polarize?
Well, I suppose if the Southeast Asians chose to give way, then they could have a code of conduct. There's no doubt about that. And the process is important. It is the process is in itself a confidence-building measure. It's a place where people can discuss their differences and hopefully reach some working solutions on certain problems. But I think the actual full-fledged COC isn't going to happen anytime soon.
Yeah. And the status quo, Nong Hong now, the status quo as it is what Greg talked about, is the smaller boats, the coast guards and the fishermen coming into conflict. But is there, I know we touched this before, but let's go back to the likelihood of some sort of deal. Nong Hong. Oh,
Can't we get to your question? Can you say it again, Humphrey?
Yes, it's a question from the audience about regional cooperation with ASEAN to thrash out a workable and binding code of conduct, but also with a view to the sort of rule of law, because Greg mentioned that China sees law as a tool of the exercise of power. So if you could touch on that.
Okay, thank you. I think, well, first of all, the regional dialogue, I think, still persisted. I think it's very important, although many of them may say the current negotiation of the COC is symbolic. It will not be actually reach concluding very soon, but I think it's still very important to provide a venue for all the claimant states and also other regional states to share their views. I think that's very important. And in addition to the regional cooperation mechanism, I think the bilateral talk between the claimant states also important. I think that between China and Vietnam, we have this Coast Guard training, not right now, a couple of years ago. And even between China and the Philippines, we do have a lot of conversation of bringing Coast Guard together, but it didn't work out lately due to the clash of the incidents in Second Thomas Shoal and also the Scarborough Shoal. In addition to that, I think in terms of the incident I see when Craig mentioned about the fishermen's interest being, I'm not quite sure. I think when we're talking about the, let's say, the current fishing conflict, it's always there. I think a Chinese proposal is to ban some fishing for some certain period because it will benefit for all the fishery conservative. I'm not quite sure I get it, but I do want to, along this side, I do want to respond to Bill's roadmap. I think it's important that it's not really a cost and benefit analysis there. Actually, if we're talking about, for instance, if China withdraw or give us some of its claims, okay, then let's say fishery or oil and gas, probably it's elsewhere. China can see to oil and gas benefits from elsewhere. So it's not really about how much China can get from its claim in the China state. It's more or less a strategic roadmap, as Pooja mentioned as well. So it's complicated, and I do hope that everyone in this region can find a simple roadmap to solve the issue, but it's not easy.
It's complicated. It sounds like a Facebook relationship. Pooja Bhatt, your final thoughts?
So, so on this issue of COC, it's so difficult to comment on some things nobody has seen, in paper. No other country except ASEAN and China has seen the document by itself. So it's very difficult to comment on something we have not seen. At the same time, as I will take it from what Bill also mentioned, that COC is necessary mechanism to resolve the matters between ASEAN and China. But even if that comes into existence maybe 10 years down the line, it would be too watered down a version to have any impact on the region. So yeah, I am So while diplomacy is good, I don't think too much of watered down version would be good for anyone.
And from where you're sitting in India, is the Trump administration or the values that are now being projected by that administration, would that have any bearing on this?
I think Trump's relationship with India is separate from how it sees Indo-Pacific region and its relation with China and Taiwan. So I don't think there would be a direct relations here, and I don't think India would be wanting to get involved directly into anything in South China Sea for various reasons, except on the multilateral level. So I don't think so. We'll have any. The South China Sea would be a direct conversation point between Modi and President Trump.
Collin Koh, from what we've heard from Nong Hong about the training of the Coast Guards and everything, and from you about the trade, am I right in thinking there is an argument that it's better to muddle along as things are going on now without bringing things to a head?
Yeah, Humphrey, that is a good question. I would think it is, given that for most of the Southeast Asian countries, domestic issues have now taken hold as a priority. You see that very evident in the case of Indonesia under the current administration, which is inward-looking and focusing more on economic, issues more than anything else. Vietnam appears to be more focused on its own economic development and thereby, doing the things on the sideline in the South China Sea without unnecessarily, hyping up issues with China. And so is the case for Malaysia and all that. But allow me to just hop onto the discussion on the code of conduct. And this is a topic that, like my friends here, we follow very closely. If you have seen the 2018 single draft negotiating text itself, you'll find that most of the proposals that will see consensus amongst most countries have largely pertained to practical security cooperation. There is no lack of proposals on things like search and rescue cooperation, fishery cooperation, whatnot. But when it comes to the very gist of the main issue, and by that I mean confidence and security building mechanisms, things like how to restrict activities by Coast Guard and military forces. All these are found severely lacking in the whole document that I saw. Vietnam is the only country that bothers to define what militarization means, because if we don't have any consensus on that, there's no way to come to a meaningful agreement, whether it's binding or not. And if you ask me, as a Southeast Asian, if we turn the clock back, it's better not to have this discussion at all. But now that we have it, it's a sunk cost, we have to go with it. And it does appear, ironically, that maybe having it continue to be just conversations rather than a fully promulgated document might actually be the way forward more than anything else. Yeah.
Conversation. Greg Poling, can I just finish with you? What could we expect from the United States to change this situation with the new administration? I gather that the Indo-Pacific or Asia sort of units have been wound down. What do you expect from it? Because you're right at the heart.
Yeah. Well, look. So in the short term, functionally, we haven't seen any indication that the second Trump administration is going to change policy when it comes to the Philippine Alliance or the South China Sea. The first meeting that Secretary of State Rubio took upon his taking office, I think the day after the inauguration, was the meeting with the Quad foreign ministers, where they issued a statement focused on maritime security. His very first call with the Southeast Asian leader was with the Secretary of Foreign Affairs of the Philippines, followed by those of Indonesia, Vietnam, and Singapore. Defense has done the exact same for parties. So you're seeing a big focus still on the alliance, a big focus on maritime security. Given the prevalence of what we call China hawks in the administration, I expect continued support there. There is a broader, I think, philosophical question about the United States' approach to international law under a Trump administration, a discussion that we have had before, the first 4 years. And I would point out this. Donald Trump and his administration will doubtless be a stressor on key institutions and components of international law. But this is, I think, qualitatively different than, say, the stresses that potential Chinese violation of international law present, for a few reasons. One, I know for a fact that Donald Trump will leave office by 2028. 2, we have a Congress. In 3 weeks, the administration will have to negotiate to keep the government open, and they will need Democratic votes to do it. We'll have a by-election year after that. The system, while under strain, is still a system built on a distribution of power in order to constrain the executive, and one in which we still have rule of law. So while I fully appreciate the weight of the United States and the international system, and therefore the waves it causes when we get a leader who doesn't necessarily agree with the rules of the system, I also think we have to appreciate that he is not King Trump. He is President Trump, and he is far more constrained than any leader of China ever will be.
On that note, I think that is a great thought to finish with. Thank you so much for that, Greg Poling. Thank you also to Bill Hayton, Nong Hong, Pooja Bhatt, and Collin Koh. We are out of time. Thank you to our audience and for those questions that came in that we addressed. Please check out our sister magazine, Asian Affairs, which, like this forum, goes deeply into issues that are not often addressed in the mainstream media. Our next Democracy Forum debate is March 19th. Syria after Assad, what next for the country and the region? But until then, from me, Humphrey Hawksley, and all at the Democracy Forum, stay safe and goodbye. Thank you very much.